Imagine the entire Council of Ministers. I mean, this huge, sprawling body. Maybe 50, 60, sometimes even 80 people.
A massive structure.
Right. Now picture the cabinet. Are they the same thing?
Not at all. And that's the core of it.
And if they're not, what's that one single critical difference that really defines where the power is in New Delhi day in and day out?
That's the question.
We are diving deep into that fine print of the Indian executive today, and we're going to uncover these nuances that are just, well, essential for any serious study of polity.
Welcome to that crucial intersection. Because that distinction you're starting with, it's not just about words. It's where the formal design of the Constitution, the big picture, meets the reality of how modern government actually works.
And understanding that difference it's everything. It's the foundation for the entire central administration.
It really is.
Absolutely. Welcome, everyone, to the Deep Dive. This is where we cut through all that noise, the information overload, and we really try to distill the critical, actionable insights from your mountain of source material.
And our mission today is crystal clear.
It is. We're synthesizing the foundational understanding of the Union executive, the fundamental rights, and of course, the judicial architecture that constrains and guides Indian polity.
This deep dive is really custom-tailored for you, the serious learner, especially if you're navigating the demanding world of competitive exams, like the UPSC.
We are not here to just read a textbook to you. We're here to unlock those critical connections.
We've drawn on a lot today: core constitutional texts, landmark case law, and we're trying to connect those structural concepts directly to the constitutional articles and, maybe most importantly, to the judicial thinking behind them.
That's the stuff that separates a good answer from a great one, isn't it?
Without a doubt.
Okay, before we jump into that first major distinction, I just need to make a quick, humble request.
Please do.
If you're finding this content super useful, and we are really, really committed to making it super useful and detailed, please just take a moment right now to subscribe to the YouTube channel Simplified UPSC by PPP.
It really is the fuel that keeps this whole research engine running.
It is. And if you're able to, please consider joining the paid membership.
That support is it's absolutely critical for us. It lets us continuously bring you this level of high-quality, targeted content, especially as we try to go deeper and deeper.
And on that note, we have to give a massive, heartfelt shout-out to all of our existing paid members.
Yes, thank you all so much.
Your support is invaluable. You truly power the creation of every single deep dive we produce. So thank you for making this possible.
And while you're there, don't forget to like this video. And please, share a valuable comment below. Let us know the most surprising insight or connection that really stood out to you.
One last thing on resources. We have free notes and practice previous year questions, PYQs, available right now on our Telegram channel.
And if you're looking to take your prep to the next level, our premium notes, extra PYQs, and model mains answers are all waiting for you on the Discord channel. That's for our legend YouTube members.
So please do join us there. It's a huge resource for structured study.
Okay, let's get into it.
All right, let's unpack this core distinction. It trips up so many students. The Council of Ministers versus the Cabinet. Let's start with the big one. The Council of Ministers, or COM. What's its constitutional mandate?
Okay, so the COM is the broad constitutional concept. Its existence is mandatory under Article 74, specifically Clause 1.
And that says what exactly?
It clearly states there shall be a Council of Ministers headed by the Prime Minister to aid and advise the President.
And a couple things that are absolutely critical for any student to know, right?
Two things, yes. First, the advice that the COM gives to the President is binding. It's not optional.
That was an amendment, wasn't it?
It was. Added by the 42nd Amendment and then reinforced by the 44th. And second, the courts cannot inquire into the nature of that advice. It's completely outside of judicial review.
So the Constitution demands this large body must exist to advise the President, who's the nominal executive. But what's it actually made of? It's not just one big group of equals.
No, it's very much a tiered system. The COM is made up of 3 distinct categories of ministers, and they're all differentiated by rank, political weight, their pay, and of course their access to power.
Okay, so what's the top tier?
The top tier, you have the cabinet ministers. These are the big players. They had the most important ministries: defense, finance, home affairs, external affairs. They are the full members of the cabinet itself.
And below them?
Below them, you have the ministers of state, or MOS.
Mm-hmm.
And this category is actually split into 2.
Okay.
Some are given independent charge of a smaller ministry or department, so they operate without reporting to a cabinet minister, but they aren't cabinet members themselves.
And the other type of moss?
They simply assist a cabinet minister in their work.
Right, and then there's a third rung.
The third, yes, the deputy ministers. They're the lowest rung. They work under either a cabinet minister or a Maraz and just help them with their parliamentary and administrative duties.
And the collection of all of these people, that's the Council of Ministers.
That's the whole thing, top to bottom.
That sounds like it could be a massive body. And politically, we've seen it happen, haven't we? The size just balloons. You get these huge councils of 70, 80 ministers.
Creating really unwieldy governance structures, yeah.
So was there a constitutional fix for that? Was something introduced to stop that growth?
That is a crucial point, and it's a great example of how governance reform leads to constitutional change. You're talking about the 91st Amendment Act of 2003.
And this was a direct response to what they called jumbo cabinets.
Exactly. It was a direct response to that problem, which usually came out of coalition politics, trying to keep everyone happy or rewarding defectors with ministerial posts. The amendment specifically put a cap on the size of the council.
So what's the limit now? What's the number?
The total number of ministers, and this includes the Prime Minister in the Union Council of Ministers, shall not exceed 15% of the total strength of the Lok Sabha.
Okay, so with the Lok Sabha at 543 members, that puts the maximum size at, what, around 81 ministers?
About 81, yes. And this legislative intervention was huge. It really stabilized the system, and it's essential knowledge for anyone studying the executive.
Okay, so that's the big constitutionally mandated body. Now let's contrast that with the cabinet. You called it the inner circle. Who's in that room?
The cabinet consists only of that first category we mentioned, the cabinet ministers. It's a very exclusive body, usually somewhere between 15 and 25 key individuals.
And qualitatively, its role is totally different.
Totally. It is the highest decision-making authority in the entire politico-administrative system of the country. Full stop.
So if the COM is the constitutional body that's designed to advise the president, the cabinet is, what, the actual political engine room?
That's a perfect way to put it. And it means they function very differently in practice, in terms of meetings and operations.
How so?
Well, the large council ministers rarely, if ever, meets as a whole. It's just too big, too structurally diverse to have a proper collective discussion.
So what does it do?
It really just performs formal functions or, rubber stamps decisions that have already been taken somewhere else.
Then by somewhere else, you mean the cabinet.
I mean the cabinet. In contrast, the cabinet meets frequently, often multiple times a week. They are the ones who deliberate, who determine policy, who coordinate between ministries, and control the financial agenda. The cabinet does the real operational work of government.
Okay, here's where the technical detail is so important for exams. The COM is right there in the original Constitution, Articles 74 and 75. But where does the cabinet get its constitutional mention? Because for decades, it wasn't even in there, was it? It was just a convention.
That's a brilliant question and a favorite for examiners. You're right. While the cabinet has always existed politically, the term cabinet was only inserted into the Constitution by the 44th Amendment Act of 1978.
Why then? Why in 1978, and where did they put it?
The timing is everything. The insertion was a direct result of the political crisis of 1975 to 77, the emergency. And it appears specifically in Article 352, which deals with the national emergency. The 44th Amendment mandated that the president could proclaim a national emergency only on the written recommendation of the cabinet.
So that was put in to prevent a prime minister from acting alone.
Exactly. To prevent a situation where the PM could just advise the president on their own or with minimal consultation, which is what happened in 1975.
Wow. So that makes the constitutional status of the cabinet incredibly specific and high stakes. It's not just an advisory body. It's the indispensable body required for the single gravest decision a government can make.
Precisely. So to sum it up for the listener, COM is in Articles 74 and 75. It's large, up to 15% of the Lok Sabha, and it rarely meets.
Whereas the cabinet?
The cabinet is the small inner functional core, maybe 15 to 25 members. It meets constantly, and its constitutional recognition is tied specifically to the power to proclaim an emergency under Article 352.
The COM implements policy.
The cabinet formulates it. That's the fundamental distinction.
Okay, so moving from the collective body to the individual who really controls it, the prime minister. The PM isn't just the head of the Council of Ministers. They are the functional head of the entire government.
And over time, in the evolution of parliamentary practice, the PM's role has really changed.
How so?
Well, they've transitioned from being seen as just the first among equals primus inter pares to being the most dominant figure in the entire system.
Which leads to that phrase you hear a lot, prime ministerial government.
Exactly. That transition is crucial to understand. In theory, the PM is just one member of the council, and they're bound by collective responsibility like everyone else.
But in reality,
the PM is the linchpin. They're the pivot around which the whole government machine revolves. Their power comes from the Constitution, from convention, and critically, from their position as the unchallenged leader of the majority party.
So let's start with the Constitution. Appointment. Article 75 just says the PM shall be appointed by the president. It sounds simple.
It sounds simple, but political reality makes it complex. The standard constitutional convention is straightforward. The president must appoint the leader of the party that commands a clear majority in the Lok Sabha.
That makes sense. It ensures legitimacy, stability.
It does. This is the de jure authority, the president acting on the de facto reality of the election results.
But where does the president move from just following convention to exercising real, actual discretion?
Okay, the president's discretion becomes active in really two main scenarios.
Yeah.
And both are about political fragmentation.
So the first is the obvious one, I guess.
The classic scenario, when no single party gets a clear majority, a hung parliament. In that situation, the president has to use their own judgment to appoint a leader who they believe can actually prove they command a majority on the floor of the House.
And we saw a pretty clear example of this back in the late 70s.
We did. Our source material cites the 1979 instance when President Neelam Sanjeeva Reddy appointed Charan Singh.
Right, after the Janata Party government collapsed.
Precisely. Singh was the leader of the coalition that had the largest support at that time. But, and this is the crucial non-negotiable part, this discretionary appointment comes with a condition.
They have to prove their majority.
They have to. The new PM must seek and win a vote of confidence in the Lok Sabha within a month. This confirms that Parliament ultimately has the final say on who is legitimate.
Okay, and what's the second scenario where the president's discretion kicks in?
It's if a sitting PM suddenly dies in office and the ruling party doesn't have a clear elected successor ready to go.
So like in the middle of a leadership contest or a coalition squabble?
Exactly. The president, just for the sake of continuity of governance, has to appoint an interim PM until the party can formally elect a new leader. But even then, the choice is usually pretty constrained by political reality and what the party wants.
Okay, now let's get into the powers the PM has within the Council of Ministers. This is what really cements their dominance. They're the gatekeepers.
They absolutely are. First, just selecting the ministers. The PM recommends who should be appointed as a minister, and the president appoints only those people.
So the president can't add someone to the list or veto someone on it?
No. The PM's choice is virtually absolute.
And after they're appointed, the PM still holds the strings?
Yes, through portfolio allocation and reshuffling. The PM decides who gets which ministry and can change it, reallocate it, reshuffle them whenever they want.
That's an immense tool for control.
Huge. You can reward loyalty, you can signal political priorities, you can make sure your most trusted allies are in the most strategic ministries.
What about when there's disagreement? Dissent within the council?
The PM has clear ways to handle that. They can advise the president to dismiss a minister, or, more commonly, they can just ask that minister to resign because of differences in opinion or poor performance.
And the ultimate expression of this is if the PM resigns.
If the prime minister resigns, the entire council of ministers is dissolved. The whole government falls. It just underscores how central their leadership is. If one minister resigns, nothing happens. If the PM resigns, the whole structure collapses.
Which brings us back to collective responsibility and the flow of information. The PM isn't just a manager. They are the only conduit to the president.
That's formalized under Article 78. The PM is the principal channel of communication between the council and the president.
So the PM must communicate all decisions.
All decisions of the COM related to administration and all proposals for legislation. The PM has to keep the president informed. This centralized control over information flow gives the PM just unparalleled leverage.
Now, you mentioned the caretaker conundrum. This is when a government has resigned, maybe after losing a no-confidence vote, but they stay in office until a new government is formed. What are the limits on them then?
This is a scenario where the de facto executive loses almost all of its real power because a resigned government has lost its accountability to Parliament.
So they can't make big decisions.
No. As the Calcutta High Court observed back in '79, the PM and the COM are strictly constrained to just carrying on necessary day-to-day administration.
Like what?
essential functions, making sure defense runs, taxes are collected. But they can't take major policy decisions. They can't sign international treaties. They can't make appointments that will bind the next government.
Their political mandate is over.
It's over.
Yeah.
They're literally just caretaking until a legitimate successor government can be formed.
So you have this dynamic tension. The PM is the real executive, the president is the nominal one, and the whole thing is held together by this thread of collective responsibility to the Lok Sabha.
That's the heart of the system.
Okay, let's take a breath there. If the PM is the engine driving the state, who holds the brake? Who defines the boundaries of the road?
That brings us directly to the bedrock of constraint, our fundamental rights.
All right, let's make that transition. From the power structure of the executive to the foundational rights that constrain and guide it. Part 3 of the Constitution, fundamental rights. This is absolutely non-negotiable for understanding Indian polity.
It is.
Let's start with a really complex area. The right to equality and the provisions for reservations. We're talking Articles 14, 15, and 16 here.
Right. So Article 14 gives you the general guarantee of equality before the law and equal protection of the laws. It's the big principle.
But the next articles start to introduce the nuance.
Exactly. They begin that process of balancing formal equality with social justice. Article 15 prohibits discrimination on social grounds, and Article 16 is very specific. It's about equality of opportunity in public employment.
And it's Article 16 that contains the most significant and often the most politically charged exceptions.
It is. It allows the state to deviate from that idea of absolute equality to try and ensure substantive equality.
How does it do that?
It allows the state to make provisions for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, isn't adequately represented in the services under the state.
So this is the constitutional gateway for affirmative action.
It is. And the most significant judicial interpretation of this provision came with the Mandel Commission report, which led to the landmark Indra case of 1992.
And we really need to go beyond just mentioning the case. We need to get into the details of what the Supreme Court actually said.
This case is vital. The Supreme Court upheld the constitutional validity of the 27% reservation for other backward classes, the OBCs. But, and this is a huge but, the verdict included several crucial limitations that really defined the rules for reservations from then on.
Okay, what were those fundamental rulings?
First, the court mandated the exclusion of the creamy layer, meaning the socially and economically advanced people among the backward classes should not get the benefit of the quota. The idea was to make sure the benefits reached the genuinely disadvantaged sections. Reservation is for backwardness, not for status.
Okay, that's one. What else?
Second, the court established a clear 50% ceiling on total reservations. It ruled that, except in some extraordinary situations, the total reserve quota in any given year should not go over 50%.
And that was to protect the principle of merit.
Exactly. To ensure equal opportunity remained the main criterion. And third, and this was very controversial at the time, the court ruled that reservation in promotions was unconstitutional.
Right. They said Article 16.4 only applied to initial appointments, not promotions.
They did. And that third point about promotions immediately caused Parliament to react.
They passed amendments to override the judgment, didn't they?
Yes, it's a classic example of that legislative response to judicial constraint. Parliament passed the 77th and 85th Amendments, among others, to specifically reintroduce reservation in promotions for scheduled castes and scheduled tribes.
Okay, let's fast forward to the most recent big change in this area, the 103rd Amendment Act of 2019, the EWS Reservation. How is this different from the SC/ST/OBC quotas?
It's fundamentally different because it introduces a purely economic criterion for reservation. It moves away from the traditional basis of historical social backwardness.
So what did the amendment do?
It inserted a new clause in Articles 15 and 16, allowing the state to reserve up to 10% of seats or posts for economically weaker sections, or EWSs.
And crucially, this is for people not already covered.
Exactly. This benefit is available only to those EWS individuals who are not already covered under the existing reservation schemes for SCs, STs, and OBCs. So it created a separate economic category within the general category.
All right, let's shift now to maybe the single most revolutionary article in the Constitution, thanks to judicial interpretation. Article 21, Protection of Life and Liberty.
Initially, its scope was so narrow. Today, it's just breathtakingly wide.
Talk about that initial interpretation, the A.K. Gopalan case in 1950.
In that case, the Supreme Court took a very narrow textualist view of the phrase procedure established by law.
And what did that mean in practice?
It meant that if a law was properly passed by the legislature, the court couldn't question if it was fair or not. It only protected you against arbitrary action by the executive, not the legislature. So, in theory, the legislature can pass an unjust law, and the courts couldn't do anything about it under Article 21.
That's a very limiting framework, and it's very different from the American due process of law idea. What was the seismic shift that happened in 1978?
That was the Maneka Gandhi case, and the Supreme Court completely changed its mind.
What did it hold?
It held that the procedure established by law must be fair, just, and reasonable. It couldn't be arbitrary, fanciful, or oppressive. This effectively infused the spirit of due process into Article 21.
So after 1978, any law that restricts life or liberty now has to pass a three-part test. It brings together the golden triangle of rights.
Absolutely. Post-Maneka Gandhi, any such procedure has to satisfy Article 21 itself. It must be a fair procedure. It has to satisfy Article 14. It can't be discriminatory. And it has to satisfy Article 19. It can't violate freedoms like speech or movement.
And it's through that expansive lens that the Supreme Court has just dramatically enlarged the definition of life.
It's no longer just about physical existence, not just about breathing. The scope of Article 21 now includes the right to live with human dignity.
Which is the foundation for so many other rights.
So many. The right to health, right to livelihood, right to a speedy trial, right to privacy affirmed, and put a Swami right to free education up to 14 years. I mean, the list goes on. It covers everything necessary for a dignified existence.
Okay, before we leave this section, let's touch on the flip side. Part 4 VA. Fundamental duties. They're non-justiciable. You can't go to court over them. So why are they still considered a crucial part of the Constitution?
The 11 fundamental duties, which were inserted by the 42nd Amendment, serve as a constant reminder to citizens that rights and duties are two sides of the same coin. They're inseparable aspects of nation building.
So even if you can't be sued for not striving towards excellence.
Exactly. But these duties, like respecting the Constitution, upholding sovereignty, protecting the environment, they act as a moral compass. And they also help courts interpret laws and decide if a restriction on a fundamental right is reasonable or not. They complete the picture of what it means to be a citizen.
All right, that brings us to the third pillar, the judiciary. This structure is essential not just for justice, but for keeping that constitutional balance. And what's immediately striking about the Indian judicial system is that it's an integrated system.
It is.
Why is that so significant in a country that's quasi-federal?
Well, the integrated system with the Supreme Court at the top, then high courts, and subordinate courts below, it's distinct because it enforces both central and state laws uniformly.
Unlike the U.S. system.
Exactly. The U.S. has separate federal and state court systems. Our single hierarchy of judicial authority ensures that laws, and especially fundamental rights, are applied consistently across the whole country. It's a powerful unitary feature.
And the independence of this judiciary is paramount. And maybe the most intense battle over that independence in recent memory was about judicial appointments, the NJAC versus the Collegium system.
Oh, absolutely. This really demonstrates how far the judiciary is willing to go to defend what it sees as its core integrity.
So explain the Collegium system first.
The Collegium system, where senior judges appoint other judges, evolved through a series of judges' cases. The idea was to ensure the executive had only a consultative role, not a decisive one.
But Parliament challenged this.
They did, with the 99th Amendment Act and the NJDC Act in 2014. The NJJC, the National Judicial Appointments Commission, was meant to replace the Collegium.
And who was on this commission?
It was a mix. The Chief Justice of India, the two next most senior Supreme Court judges, the Union Law Minister, and two eminent persons who would be nominated by a committee.
So the idea was to bring in some executive and non-judicial representation, some outside perspective. So why did the Supreme Court strike it down?
In the landmark Fourth Judges case in 2015, the Supreme Court declared the 99th Amendment and the NJAC Act unconstitutional and dealt void.
And their reasoning was?
The court ruled that including the law minister and the way the two eminent persons were to be appointed introduced a real risk of political interference in judicial appointments.
Which they saw as a violation of judicial independence.
A fundamental violation of judicial independence, which the court has held, is a key element of the basic structure of the Constitution. So the court nullified an entire constitutional amendment and restored the Collegium system.
And that power to nullify an amendment rests entirely on the doctrine of basic structure. For any learner, we have to understand the fundamental shift this doctrine created.
The doctrine of basic structure, which came out of the monumental Kesavananda Bharati case in 1973, is the ultimate judicial check on Parliament's power. Before 1973, the general belief was that Parliament could amend any part of the Constitution under Article 368.
So what did that 1973 ruling establish?
It established that Parliament's amending power is not unlimited. It said that while Parliament can amend any provision, it cannot alter, destroy, or abrogate the basic structure or the essential features of the Constitution.
So it's a philosophical shift. Sovereignty doesn't lie with Parliament.
It lies with the Constitution itself, and it means certain features. Judicial review, federalism, secularism, judicial independence are basically off-limits. They're inviolable.
And this doctrine was tested almost right away during the emergency and with the 42nd Amendment.
Yes. The 42nd Amendment tried to do two things. First, say that Parliament's amending power was absolute and couldn't be reviewed by the courts. And second, it tried to give all directive principles precedence over fundamental rights.
But the Supreme Court pushed back.
It did. In the Minerva Mills case in 1980, the court used the basic structure doctrine to nullify those provisions. It held that the harmony and balance between fundamental rights and directive principles is itself an essential feature of the Constitution. You can't disturb that balance.
Okay, let's clarify the difference between two critical actions of the court: judicial review and judicial activism. They're related, but they're not the same thing.
Right. Judicial review is the formal constitutional power. You find its roots in Article 13 to examine the constitutionality of laws and executive orders.
So if a law violates the Constitution,
The court can declare it null and void. It's an essential check and balance.
so how is judicial activism different?
Judicial activism is distinct because it's the court using its power to, in a way, mold or create law. It often happens when there's a vacuum where the legislature or the executive has failed to act, and the court steps in to respond to social change.
So it's proactive, not just reactive.
Exactly. It's about evolving new concepts, expanding the scope of rights like Article 21 to achieve social justice, where the traditional separation of powers might have led to inaction.
And the main vehicle for this activism has been public interest litigation, or PIL. Why was PIL so revolutionary when it first came along in the 80s?
Because it completely dismantled the rigid traditional rule of locus standi. Traditionally, only the person who was actually aggrieved, the one whose rights were violated, could go to court. PIL relaxed this. It allowed any public-spirited citizen or social organization to go to the High Court or Supreme Court on behalf of the poor, the illiterate, or any disadvantaged group that couldn't access justice themselves.
And this opened the floodgates for cases on things like bonded labor, environmental damage.
Police harassment, child rights violations, yeah. It democratized access to the highest courts in the land.
But with any powerful tool, there have to be limits.
There have to be. And the judiciary itself has cautioned against going too far, warning that judicial activism must not become judicial adventurism.
Meaning judges shouldn't become policymakers.
Right. The courts have stressed the need to respect the separation of powers and the expertise of administrative authorities. The judges have to avoid substituting their own policy preferences for those of the elected legislature. It is a very, very delicate balance.
Okay, for our final section, let's connect all these constitutional concepts with some quick, highly relevant links that bridge the theory to what you actually need for the exam.
Let's do it.
We've called India a quasi-federal state. Let's start with why Article 1 calls India a union of states and not a federation of states.
This simple phrase has two profound ideas behind it, as Dr. Ambedkar pointed out. First, the Indian Federation isn't the result of some agreement between states.
They didn't come together to create the union.
No. And second, and this is the most important part, no state has the right to secede from the federation.
Which leads to that famous description of India as an indestructible union of destructible states.
Correct. The ultimate power here lies with the Union Parliament. Under Article 3, Parliament can unilaterally change the area, the boundaries, or even the name of any existing state.
And all it takes is a simple majority.
A simple majority. Compare that to the U.S., which is an indestructible union of indestructible states. Their federal units have much greater territorial integrity. This central power reorganization is a critical, non-federal feature of our Constitution.
Speaking of central power, let's circle back to the emergency provisions, specifically the changes from the 44th Amendment in '78. Another direct response to executive overreach.
Yes, the 44th Amendment brought in three huge changes to prevent the misuse of emergency powers. First, it replaced the vague term internal disturbance with the much stricter term armed rebellion for declaring a national emergency.
That's a much higher bar.
Much higher. Second, It mandated that the proclamation must be based on the written recommendation of the cabinet, which we talked about earlier.
And the third change brought the judiciary back into the picture.
Absolutely. The 44th Amendment removed the provision that made an emergency proclamation immune from judicial review. And later, in the Minerva Mills case, the Supreme Court confirmed that a proclamation of emergency could be challenged in court.
On what grounds?
On the grounds of malified intention, bad faith, or if the decision was based on completely irrelevant facts. The judiciary reclaimed its role as a check, even during a national crisis.
Let's move to the grassroots. The constitutionalization of local governance with the 73rd and 74th Amendments. What structural mechanisms did they create to ensure real decentralization?
These amendments were transformative. They changed local governance from being just an optional policy to a constitutional mandate. They set up a uniform three-tier structure for panchayats and municipalities.
And they mandated reservations.
Yes. Crucially, they mandated the reservation of seats for SCs, STs, and women at all levels of local government.
And how do they ensure independence from the state government, particularly for elections and finances?
They mandated the creation of two constitutional bodies at the state level. The State Election Commission, or SEC, to conduct local body elections neutrally.
And the State Finance Commission.
The SFC, yes. It reviews the financial position of the local bodies every 5 years and recommends how taxes, duties, and grants should be shared between the state government and the local bodies. That financial independence is the key to real devolution of power.
Okay, finally, let's connect the expansive interpretation of Article 21, the right to dignity, with some really recent contemporary issues.
This is a perfect example of the living constitution at work.
Start with the Puttaswamy case of 2017.
Seminal. It declared that the right to privacy is a fundamental right, that it's integral to Article 21 and the basic structure of the Constitution. This was all about recognizing the dignity and autonomy of the individual against the state.
And how did that foundational principle then get applied to other rights?
The very next year, in the Navteej Singh Johar case of 2018, the Supreme Court decriminalized consensual homosexual acts.
And they explicitly linked the old law, Section 377, to the Golden Triangle.
They did. They said it violated Article 14 because it was an arbitrary classification, Article 15 because it was discrimination based on identity, and Article 21 because it was a deprivation of dignity and autonomy. It's a perfect demonstration of how the judiciary uses these core principles of fairness and non-discrimination to guide and constrain government action.
That was tremendous deep dive. We started by really deconstructing the functional core of the Union Executive, tracing that critical difference between the big Constitutional Council of Ministers and the powerful policymaking cabinet.
We looked at the dominance of the Prime Minister, how their power is exercised, and, importantly, the constraints on that power, like the caretaker role.
Then we transitioned to the essential constraints on government, didn't we? We delved deep into the evolution of fundamental rights, from the technical judicial limits on reservation in Indra to that revolutionary expansion of Article 21 after the Maneka Gandhi judgment.
Which just redefined what life and liberty even mean in India.
And finally, we analyzed the judicial oversight mechanisms, the basic structure doctrine that stops Parliament from destroying the Constitution's core, and the rise of judicial activism through PIL, along with its limitations.
You see, success in mastering this field, it really requires synthesizing these layers. You can just memorize the articles. You have to understand how political reality and judicial interpretations have molded the original design into this dynamic, living document that governs India today.
It's all connected.
It is. And let me leave you with a final provocative thought to chew on.
Go for it.
We noted that Parliament's power to create a new all-India service, like the IAS or the IPS, is conditional. Under Article 312, Parliament can only pass an act to create such a service if the Rajya Sabha, the House representing the states first, passes a resolution to that effect by a special majority.
Ah, a unique power of the Rajya Sabha.
A unique power. So what does this specific check on the Union's power, vested uniquely in the chamber that protects the federal units, tell us about the foundational commitment to cooperative federalism, even in the highly centralized world of all India services and administration?
That is a great question. Think about that delicate balance, that tension between unity and federalism as you continue your preparation.
We truly appreciate you spending this intensive time with us on the deep dive. Our goal is to make sure you walk away comprehensively informed and ready to tackle those complex, multi-layered questions.
And a final reminder, if you found significant value in this detailed discussion, please subscribe to our channel, Simplified UPSC by PPP. Your support is vital, and considering joining the paid membership helps us sustain this level of high-quality, targeted content creation.
Don't forget, the free notes and practice PYQs are waiting for you on the Telegram channel, and the premium content, extra PYQs, and model mains answers are available on the Discord channel for our Legend members.
Keep learning, stay curious, and we look forward to having you on the next deep dive.